Now, today, the Office of the Director of Public Prosecutions launched a review of pending files at the Nairobi remand prisons. The launch aims at decongesting the country's prison, which has passed its capacity. The DPP plans to institute interdisciplinary efforts in order to ensure speedy justice for the petty offenders being held at the prison simply because they cannot afford the plea bargain.
We look at the matter from the perspective of the National Prosecution Office. As it must be, this effort is multidimensional and requires a multi-agency combination. This is because its success cannot lie in the work, however excellent, of a single department or body. Success depends centrally upon the involvement and active cooperation of every sector in the criminal justice system. It is for this reason that I especially acknowledge the presence of Her Ladyship, the Honourable Justice Lesit, representing the judiciary, which is a significant stakeholder in the criminal justice system. I also note that the attendance of the Law Society of Kenya representative and senior members of the bar, we have one senior member of the bar, Mr. Ojiambo, and others. The legal fraternity can play a key role in ensuring expedition in court cases. There are also other sectoral representatives, you have seen them, all of whose participation and contribution is invaluable in this project. I pay tribute to you all for your interest and presence. As a special case, however, permit me to mention the Kenya Prison Service. When I spoke to the Commissioner General, Mr. Osugo, and I told him about this initiative, he was very excited. In fact, he told me to come that afternoon, but it was too short. The service is most affected by any mistakes, deficiencies, or failures by all the other agencies higher up the food chain of the criminal justice system. They suffer the consequences and rarely reap the benefits of the actions of those before them in the pipeline. This event is therefore purposely held within the precincts of the prison of the Nairobi Remand Prison in order to emphasize, by demonstrating physically, the challenge which today we set out to meet and which, in due course, we hope to vanquish. The challenge is the blight of overcrowding in remand facilities nationwide. Overcrowding in penal or correctional institutions is not a uniquely Kenyan phenomenon. It is a global problem with which national governments and other international and transnational institutions and authorities are constantly grappling with. Strategy upon strategy has been rolled out globally to find a lasting solution. Today marks the DPP's renewed onslaught on the Kenyan version of this perennial blow to the criminal justice system. Overcrowding in penal or correctional institutions is a natural consequence of a number of social realities. For instance, it has been noted in a publication by the United Nations Nations Office on Drugs and Crime, UNODC, entitled Addressing the Global Prison Crisis Strategy 2015-2017 that the general growth of population, coupled with deficiencies in the state's criminal justice system and of policies, which include excessive use of pretrial detention, lack of access to legal advice and assistance, scarce use of alternatives to imprisonment and detention detentions used as first resort for children in conflict with the law, are among others major causative factors of overcrowding in pretrial detention centers. For although those places are the final destination for the persons who are processed through the criminal justice system, they are often least regarded in the entire process.